podcast is provided for informational and educational purposes only and should not be construed as legal advice. Because every situation is unique, you should consult with a qualified legal professional for advice specific to your circumstances. If you need legal guidance, please reach out to an accredited attorney or contact us to schedule a consultation. Hello, and welcome back to the Veteran Benefits Podcast. I'm your host, Rebecca Deming. Today, we are going to be talking about board hearings. What is a board hearing, how to prepare for one, whether choosing the hearing lane is a good option for you, and kind of some other strategic ways that we can use the hearing lane at the board in certain situations to help keep the claim moving and preserve all of your appeal rights. So we've talked in prior episodes about the Appeals Modernization Act and your different appeal options. So if you get a decision under the AMA, the Appeals Modernization Act, you have the right to choose a higher level review in which you cannot submit new and additional evidence. You have the right to choose a supplemental claim. You can always add new and relevant evidence with a supplemental claim, or you can go to the board. And at the board, you can choose a direct review lane, which we've talked about. You don't submit any additional evidence. You can choose the hearing lane, or you can choose the evidence development lane, where you don't get a hearing, but you have 90 days after filing the board appeal to submit additional evidence. So at the hearing lane, on the form, it's the same form that you use if you're choosing the board appeal, form 10182. You just check a box and say, do you want to do direct lane, evidence development lane, or hearing lane? If you choose hearing lane, you can also choose in person. You can choose a remote one where you go into the regional office, or you can choose a virtual hearing. Nowadays, almost all of them are virtual. If people have issues with technology, that's probably not our listeners here, but it might be somebody that you know. You can go into the VA regional office. In the past, board judges would travel around the country and hold them in person there. More recently, what we've been seeing is that the staff at the regional office will set up a kind of a conference room for you. They'll take care of the technology stuff, the connectivity, and get you in a virtual meeting with the judge who's sitting at their home, usually in DC. Some of the judges might also be working remotely because of all of the remote technology for holding these hearings. So it doesn't say on the form. I think it gives some estimates on the website, but the hearing lane is the longest lane. It is. I know a lot of people are like, "Well, I just want to. I want to. I want to have my day in court. I want the judge to hear me. I think if I talk to the judge, they'll understand what's going on. I just want to be heard." Understand that if you're choosing the hearing lane, you're likely going to be waiting several years to have a hearing, and then after that hearing, we've been seeing the board take usually about a year to decide the case. Recently, we are not always seeing the same board judge who holds the hearing be the one who issues the decision on the case. So what happens is you have this hearing, you give your testimony, you talk to the judge, and we'll get into what exactly happens in those hearings here in just a sec, but you talk to the judge. The board writes up a transcript of exactly what was said. Your testimony is under oath. That gets submitted into the record, and then it could be that judge, or it could, oftentimes it's another judge will get the full record plus a transcript of your hearing, and then that's what they use to make their decision. So understanding that, sometimes it's more beneficial time-wise, and it's going to add the same type of evidence to the file to just write up a sworn statement and get that into the evidence and do either a supplemental claim followed by direct review at the board, or do the evidence development lane at the board with your statement instead of waiting to have it recorded and transcribed, added to the record through the hearing. There are a few times where having a hearing is really helpful. I think sometimes when there's a complicated fact pattern, or if you don't have a representative, being able to just talk to the judge can be helpful. The judge is required to let you know what additional evidence they think your file is missing that might help your case. So if you go to the hearing and let's say the judge identifies that you're missing a diagnosis for the condition, they need to tell you that that's kind of the piece that's missing. and give you time after the hearing. You'll have, I believe it's 90 days after the hearing, to add in additional evidence. So if the judge will tell you what evidence is missing and give you time to go get a nexus letter, or go get a diagnosis, or get a statement from a friend or family member that substantiates your story. So sometimes having that can be really helpful, but oftentimes, especially if you're working with a representative, it can just add delay, and there's not a whole lot of added benefit to actually having those hearings if you have a record that's put together well enough that stands on its own without having to talk to the judge. Another reason sometimes people opt for the hearing lane is because, as I mentioned, you have that period of time after the hearing to enter new and relevant evidence. Usually it's the evidence that by talking to the judge, you both identify would be helpful to the claim. You can add that after the hearing. Sometimes, we have veterans that are traveling overseas for work, or for whatever reason, they're not able to get the diagnosis that they need or build that evidence now. Or maybe they're waiting on another claim to be decided, and then this claim that's at the board kind of hinges on something else that's pending in another lane. And so you want to just sort of stick a pin in it. And so sometimes going hearing lane at the board is the best way to stick a pin in something, because once whatever else happens, once you get back to the States and can gather that medical evidence, or the other claims that you were waiting on get decided, you can waive the hearing and add in the new and relevant evidence at that point, and you haven't lost out on the claim. So remember, to get the earliest effective date, you want to have continuous pursuit. So you don't want to drop something and then pick it up 3 years later. You always can, but if you do that, you might be missing out on 3 years worth of back pay. So keeping something pending because the hearing lane takes so long, it is a strategy. We don't use it often, but sometimes if we want to keep something alive for benefits purposes, but we know it's pending or hinging on something else that's out of our control, going the hearing lane with understanding that you might waive that hearing down the line can be helpful. Sometimes people come to us and they have selected the hearing lane and they want us to represent them at the hearing. And I'm always happy to hold a hearing with someone and walk them through the questioning and kind of presenting their story to the judge. But sometimes we'll look at the records and determine, and they didn't know at the time because they filed on their own, there's really no benefit to having this hearing. What we need to do is just waive the hearing and then add in the evidence that's missing from the file that we think is the most important to get the grant. So we're trying to move the case along as quickly as possible for you, but not miss out on any opportunities to build the record and support your case. Okay, so that's kind of the strategy part about choosing the lane, timelines, when we add evidence, why you might choose the hearing lane, why you might want to have a hearing with the board judge. What can you expect in a hearing? I know a lot of people lose sleep in the days and weeks leading up to a hearing. They're really nervous. They have to talk to a judge. I don't think there's a whole lot of information on VA's website about what to expect in these hearings, but they really are very informal, and it's still in what VA calls the non-adversarial stage of the case. So the board judge is not there to catch you in a oopsies. It's not like you're going into, if you watch a lot of Law and Order and there's a lot of procedural, Your Honor, I object, may it please the court. It's, you want to be respectful. You want to dress nicely. You don't have to wear a suit. I often recommend a collared shirt, but it kind of depends on the veteran. Some people just really you want to be comfortable is the most important thing. And so if you're going to be comfortable in a t-shirt in your living room, that is totally fine. Again, like I said, the judge who holds the hearing is often not even the one making the decision. So your impression on what you're wearing or how you look really doesn't weigh in that much into the decision, often not at all. So if you aren't represented, the judge will talk to you, tell you why you're there, tell you that it's non-adversarial, and they have read the record, they've read the pleadings going up to there, and they will ask you some questions, and they will try to pull your story out of you and have a dialogue. And it's not a gotcha moment. It should not be intimidating. The judges that I've had conferences with, it has not been intimidating. They are really there to help the veteran tell their story, get their story on the record. They know that you've been waiting a long time to tell your story. And so they want to give you the opportunity to tell your story and make sure that you're capturing all of the pieces that are going to be important to the case. So if you start going down a rabbit hole of something that's not really important to the case, but it's important to you, they might not cut you off. But when you finish talking, they will redirect you and say, okay, thank you for telling us that. What we need to know is XYZ. So if you're not represented, actually having that conversation with the board judge can be really helpful because it will help you have a conversation with somebody who knows what's important to the decision maker and will ask you the questions to help build out that record and give you an opportunity to talk about your range of motion or why you didn't go to the doctor in service or how frequently you're having migraines and not just how frequently you're having migraines, but are they the type of migraine that really knock you out and meet the requirement for fully prostrating and prolonged for a 50% rating. So they will draw out a lot of those details with you if you're not represented. If you are represented, the way that I prep my clients for it is we'll have a few meetings before the conference. I want to try to ease your nerves as much as possible, explain to you what's going to happen, which is what I'm doing here. And then we'll go through the questions that I'm going to ask you. I don't want it to sound rehearsed because it's your opportunity to tell your story. And if the story is really coming more from me than from you, then it doesn't do you justice. But I want you to be comfortable. I don't want there to be curved questions that you're not prepared to answer. I want to make sure that we know that we are both on the same page about what pieces of your story are most important to get out to the judge. So I will have a list of questions. It depends on the client. Sometimes they really don't need a lot of prompting and I can say, okay, tell me your story. Let's start here. And they can kind of go. Sometimes it's a little bit more, I'll ask questions and we'll get one sentence answer. And then I'll ask the next question and help you build out your story. We can ask leading questions. So for anyone who's kind of watched trial TV or something, it's fine for me as the representative to say, Mr. Jones, isn't it true that you were having trouble doing this? And you can just say, yes, that's very true. And there's nothing wrong with that. Like I said, I think it's adds credibility if you're able to tell the judge those things in your own words and you're not just answering yes to my leading questions. But sometimes I know there's a lot of nerves and people kind of get off track. And so I can use those as tools to kind of get the veteran back on track, telling their story and telling the parts of their story that are going to matter to the court and matter to the board in making a decision. Once I finish going through our set of questions, and I can also kind of give us an opening statement. It's not so formal as an opening statement usually, because it really is more of a discussion. And any kind of opening statement, I usually put in writing in the brief that I submitted. But I do want to kind of frame the issues for the judge, make sure that we're on the same page for things. Once I finish kind of our side of the story, going through the story with you, the veteran, the judge has an opportunity to ask questions. And it's not like cross-examination. They're not, I have so many, I mean, I know I'm saying this ad nauseum, but I have so many clients that are just really afraid that the judge is going to question them on their memory and catch them messing up, not because they're being dishonest. I don't work with people that I'm worried about that they're lying, but they're just worried that, well, what if I didn't remember that exactly correctly? Or what if I had said it was Fort Hood, but it was really Fort Bragg, and whatever. The little details, they're not trying to trip you up. If your story has inconsistencies, like major inconsistencies and you come across as not credible, of course that can factor into the decision, but they're not trying to like question your motivation or grill you on your story. They're really trying to give you an opportunity to pull out the story. So once we get through our questioning, the judge will ask additional questions. And that's really just things if the judge is saying, I really would like to have more details on this piece. Can you tell me a little bit more about that? And that part usually only lasts a few minutes, depending on how many additional questions the judge has. And then the judge will say, hey, with everything you have, I think it really would be helpful if we got another medical opinion that specifically addresses this question. Or, I see that you've been suffering from these symptoms, but I don't see a diagnosis in your records. It would be really helpful if you can talk, in the next few months after this hearing, if you can submit evidence from your doctor that shows you have a diagnosis. whatever the evidence that they think is missing, they need to tell you what that is. So you have an opportunity to get that into the record. And then you wait. And it can be an emotional roller coaster because I think people, you waited often 3, 4, 5 years to have a hearing. Then you have the hearing, and now you're waiting again for a decision. And it can be often about a year, give or take a little bit, before you get a decision after the hearing. So it's like all the adrenaline's out. Like I did my hearing, it's over. It wasn't as bad as I thought. And now you have to wait for that decision. And then when you get the decision, it could be a few things. It could be a grant. If the board grants something, it gets sent back to the regional office to implement that grant. So the regional office is the one that's going to assign an effective date, assign a rating level, and calculate your back pay, calculate your pay going forward. So all of those pieces. And that usually happens within a few days to a few weeks of getting the board decision. So if it's a grant, there's still an extra piece. You still have to wait a little bit before you get your money. If it's a denial, you can file a supplemental claim and add in the additional evidence that, new and relevant evidence if you think there's something else that would help your case, or you can go to the court. And you can go on your own to the court. If you went through the board and didn't get representation and you're still getting denials, it really is a good time to get an accredited legal representative involved in your case if you're going to go up to the court. So that's a denial, a grant. The third thing that the board can do is a remand. And a remand is kind of like the duty to assist error from a higher level review. A remand sends the case back down to the regional office and says, hey, we didn't get all of the evidence that we needed to make the decision. Sometimes that's social security records. Sometimes that's a medical exam wasn't adequate, and they're going to send it back with instructions for the medical examiners to answer specific questions. Sometimes it's looking into whether or not there was toxic exposure risk activity or certain exposures, pulling certain service records. So if it gets remanded, you're all the way back down to, it's like a game of chutes and ladders. You're all the way back down to the people that messed up your claim the first time, but now they have instructions from the board that they're required to follow. I say they're required to. Sometimes as representatives, we have to hold their feet to the fire to make them follow the instructions from the board. If they don't follow the instructions, sometimes we're back up at the board saying, you guys gave them instructions to do X, Y, Z, and they didn't. We're back up here. Please make a decision. So they are required to follow the board's instructions to get the additional evidence, make a new decision, and then you have your full set of appeal options once you get a decision back following a board remand. So that is, in short, what to expect with a board hearing. And we talked about why you might choose a board hearing, why if you chose one, you might end up waiving it to speed up the decision at a certain point. And why you might decide that a board hearing, even though it looks nice on paper, might not be the best option for everybody if you're able to develop your case without having a board hearing, just because of the timelines of waiting to have a board judge sit down and talk to you about your case. So if this was helpful, please comment, ask any questions that you have in the comments, and give us suggestions of other topics you'd like to hear us talk about. And like, follow, and subscribe, and we will see you next time. Thanks for joining.